Caribbean Court of Justice, original jurisdiction, hearing of the application AR1 of 2008 for leave to commence proceedings by Trinidad Cement Limited, TCL Guyana Incorporated versus the government of the Co-Operative Republic of Guyana.
Please, Your Honors, I appear for the applicants. With me are Mrs. Bertram and Morgan from the Guyana Bar, instructed by Mrs. Denton.
Please, Your Honor, Mr. Dumont Singh, Senior Counsel, appears to the Co-Operative Republic of Guyana. Mr. Bashish Maharaj, Mr. Nareshwar Hanuman, and I are with him.
Please, Your Honor, I appear for the contracting parties, the Republic of Trinidad and Tobago, instructed by Grace Shanky.
Thank you. Dr. Denbo, we want and Mr. Attorney, we would like to have some idea of how long you plan to take in oral submissions, and that we can decide whether we can accommodate that length of submission. Dr. Denbo.
I would suggest 1 hour or thereabouts.
1 hour?
Yes.
Well, that is acceptable. Yes, and Mr. Attorney?
Your Honors, I would say about half an hour I would respond.
Oh, well. Very well. Let us proceed. Dr. Denbo, would you come forward to put this?
May it please Your Honor, this is an application by the applicants Trinidad Cement Limited and Trinidad TCL Guyana Incorporated for special leave to prosecute proceedings against the government of Guyana. The application is brought pursuant to Article 222 of the revised Treaty of Chaguaramas, and it is supported by or founded upon special leave application filed on the 3rd of April 2008, to which was annexed the originating application in draft, as required by Rule 10.4. Now, Your Honors, before I come to briefly deal with the contents of the application, if I can give Your Honors an overview of this case to put it in its factual context.
Dr. Denbo, I thought we got notice of a proposed amendment. Is that correct?
Yes, sir. We had
It dealt with now.
a housekeeping matter.
Yeah.
The proposed amendment is annexed to the submissions filed on the 2nd of June. And it is labeled K to follow the sequence of the originating application. And if I can take Your Honor to that proposed amendment, it's dealing with paragraph 55 of the originating application. If I can just put it up on the screen. And it seeks to add to the question of prejudice or damage to Trinidad Cement, for short TCL, I believe this matter emerged from the case management conference on the 21st of May. And we have sought to set out at the new paragraph 55 the loss which will accrue to Trinidad Cement Limited as a result of the non-implementation of the CET for the year 2007. And your honors will see that paragraph 55 in red is accompanied or exhibited to paragraph 55 would be a schedule showing the flow-through loss, if I may call it that, as an 80% shareholder of TCL and TGI. So that is the nature of the amendment being sought. And I respectfully ask your honors to grant that amendment.
Mr. Teddy, is there any objection at the amendment?
There is no objection.
Well, it is granted in terms of the application.
Much obliged. Your honor, there is also a minor amendment also in relation to the relief to claim interest from the date of the loss. Your honors will see that appears at the end of the application on the paragraph 55.
Yes. Well, that amendment will also be granted.
Much obliged.
I take it there's no objection now, Mr. Teddy, to that.
There is no objection.
No objection, thank you.
Much obliged. So, your honors, if I could move on to deal with what I said at the outset would be the overview or factual background to this matter. In essence, what we have before your honors this morning is a claim by the applicants to enforce...
Before you go on, I want to understand that the loss for which the Trinidad, the parent company, is alleged to have suffered.
Yes.
Is by way of it's a loss which they, put it this way, it is a loss of income which you say they would otherwise have obtained from their subsidiary.
Yes.
So that I notice that there is no claim in respect of loss occurring as a result of loss of sales by the parent to the subsidiary.
No, so the loss of sales claim resides in the subsidiary, TGI.
Beg your pardon?
The loss of sales claim resides in the subsidiary, TGI.
Yes, I know that that is a loss claimed on behalf of the subsidiary.
Yes, sir.
But the transactions between the parent and the subsidiary, when the parent shipped cement to the subsidiary, was that by way of sale? Or?
Well, my instructions I would imagine that's by way of sale, yes, sir.
Well, anyway, you are not claiming any reduction in the sale of the parent company's product to the subsidiary as a result of the suspension of the CET.
No, sir, there's no such claim.
All right, thank you.
Yes, sir. Now, what is before your honors this morning is a claim by the applicants for damage and relief suffered as a result of the breach of the treaty. And that breach arises, in my respectful submission, from the obligation assumed by the government of Guyana by virtue of Article 9 of the treaty to implement and put into place the CET as one of its primary obligations in respect of this matter. There has been a breach of that obligation when one has regard to Article 82, in that the government of Guyana has failed to implement the CET in relation to cement from non-community countries. And there's also been a breach of Article 83, in that insofar as there was any reason to seek a waiver or suspension of the CET, the government of Guyana has flagrantly refused to do so. So this is a case about a breach of treaty obligations. Nothing to do with supply, as I will point out to your honors, as the proposed defendant has sought to suggest. It has nothing to do with the supply or the ability to supply cement. What it has to do is with a breach of Guyana's treaty obligations. Guyana simply has not adhered to the requirements of Article 82 and Article 83. Now, Your Honor, having said that, the case assumes a certain importance which transcends the narrow corporate interests of these applicants. Why it is important is because one is dealing here with the integrity of the treaty. And what the treaty and its preamble suggest has been fundamentally cast aside by this conduct. We're dealing here with a corporate group which, on the evidence in the originating application, the draft originating application, quite clearly distinguishes it as a group indigenous to the Caribbean, engaged in manufacturing a product which is comprised of Caribbean raw materials. So there's a certain uniqueness about this group of companies. I dare say one would find it very difficult to identify another group similarly circumstanced. And what one has in the context of the preamble to the treaty are some clear guidelines which emphatically indicate the intendment and the spirit behind the founders of that treaty. There are three main elements which I like to draw to your Honor's attention. And these elements are to be derived from the preamble. The first element is that the whole concept of the CSME and common market speaks to a liberalized, integrated internal market of some size, which would create favorable conditions for sustained production of goods and services on an internationally competitive basis. That is one of the main aims of the treaty. Secondly, when one looks at the preamble, another of the main aims of the treaty would be to maintain a sound and stable macroeconomic environment conducive to investment and the competitive production of goods. That's another of the main aims set out in the preamble. And thirdly, one of the main aims is to create a protected economic zone or market across borders, which would encourage manufacturers to engage in cross-border investments and attain a high level of efficiency in the production of goods, thereby enjoying economies of scale and leading to sustained economic development for the Caribbean. Now, all of these objectives are being fatally, fundamentally undermined.
I'm sorry, just repeat the third one again.
The third one, I suggest, Your Honor, is to create a protected economic zone or substantial internal markets across borders so that manufacturers can develop a high level of efficiency in the production of goods and services. And in that context, engage in cross-border investments, thereby deriving economies of scale for the long-term benefits of the economy of the region. Those, I respectfully submit, are the main objectives to be extracted from the preamble. Yes, sir.
May I ask then, you agree then that under Article 222, even though an applicant satisfies the conditions expressly contained in that article, the court still retains a discretion to withhold special consent. Is that a position, or is that special leave? That special leave, is it a matter of entitlement once the applicant has fulfilled the required conditions, or conditions, or what?
Well, I would suggest that once the conditions have been fulfilled, in the absence of special circumstances, the discretion ought to be exercised in favor of granting special leave. I wouldn't say that the court always retains discretion, but if the conditions have been fulfilled, I would respectfully suggest that there ought to be special circumstances to deny the grant of special leave.
Well, I think that the respondent has argued that the other way around, that the expression special leave carries the connotation that the applicant has to show special circumstances.
Yes, I have noted that argument in my respectful submission, as we've sought to do in our submissions in reply, is that the authorities which have been relied on in support of that submission are cases where the applicants had already been granted a process of adjudication or due process. They had gone through a trial or a hearing before specialist tribunals and had their day in court already.
Yes, they relate to special leave to appeal.
Yes, sir, special leave to appeal, whereas this is special leave to commence proceedings.
Yes, go ahead.
Much better. So, having regard to the three, what I respectfully submit, the three overriding objectives which I've sought to extract from the preamble to the treaty, I would respectfully submit to your honors that in that environment, the question of certainty is one of the essential hallmarks to nurture and underpin those objectives. One cannot have an investor engaging in cross-border investments and manufacturing on a substantial scale as we've had here, and having to be exposed to the whim and fancy of a regional government removing the CET unilaterally and without cause. So that what we have here is conduct which runs fundamentally contrary to all the main objectives of the treaty. What we have here is a severe blow to the integrity of the treaty, and in the absence of judicial intervention, it could retard and impede the progress towards economic integration. So there's a substantial public interest involved here in my respectful submission. Now, Your Honor, the final area I'd like to turn to in my opening is the question of the conduct of the Guyana government. And this is especially important having regard to what I've said. Your Honors will have noted from perusal of the originating application that the conduct, to put it at its lowest, involves patent disregard for community law. We have had here, first of all, the 24th meeting of COTED, the Council on Trade and Economic Development, which is Exhibit I to the originating application. And at that meeting, if I can just take Your Honors to that exhibit very briefly. That is the 24th meeting of COTED, held from the 13th to the 15th of November, 2007. Your Honors will see on the first page of the exhibit after the heading of that document, Your Honors will see that the minutes of that meeting, under the heading paragraph 5.3, it said implementation of the CET on cement. That's Exhibit I to the draft originating applications. Paragraph 5.3, headed implementation of the CET on cement. Under the COTED, it says, if I may read it very briefly, noted that there were no requests for suspension of the CET. And the next heading also noted, Roman 1, information submitted by CAIC on behalf of Jamaica that supplies of cement from TCL and Arawak Cement were available to meet the needs of Guyana. And Roman 2, additional information supplied by Barbados that from informal consultations, 200,000 tons of cement would be available in 2008 from Arawak Cement Limited. Further noted that in the circumstances of available supplies of cement from the region to meet Guyana's demand for cement, Guyana would be expected to apply the CET on cement imported from extra-regional sources. Noted that Guyana had not requested a suspension of the CET on cement. So it's very clear from that its CARICOM partners at that meeting would have been saying to Guyana, look here, you haven't requested a suspension of the CET. Your prior concerns about supply issues are no longer well-founded. You should go ahead and have the CET put in place once again.
But, Dr. Denver, I am reluctant to stop you.
Yes.
But how is the behavior of the Guyana government relevant to this application?
So it shows, in my respectful submission, a certain steadfastness and defiance in complying with its treaty obligations.
And how is that? How does that impact on this application?
In my respectful submission, sir, it goes to the exercise of Your Honor's discretion as to the grant of leave, because what?
Yes, again, I speak only for myself. And I would have thought that it would have been perhaps better if you focused on showing that you satisfy the express conditions contained in the Article 222. And perhaps I can ask for your assistance with regard to a couple of the questions which appear to me at the moment to arise from the interpretation and application of that article to the facts of this case. Do you want to continue with
Well, yes, I appreciate your Honor's intervention so that we could keep it within the bounds of the time limit.
Yes, all right. Well, perhaps the first matter I would raise is that this expression in 222, yes, it says, pull it up. Yes, it starts off persons natural or juridical of a contracting party. Does that mean nationals of a contracting party? National is not used, but is that how it's to be construed?
I would venture to suggest yes, sir. Especially when one goes to the Rule 10.4. In that context, one would construe it to mean a national, whether individual or a natural or juridical person.
You may also appear to look at, I think, Article 24 of the CCJ agreement itself.
Sorry, sir?
24 of the CCJ agreement itself. It speaks of nationals, not persons. Okay.
But I also that so that we then have to apply the definition of national in Article 22(5)(a).
Yes, sir.
Right?
Yes, sir.
And that contains, in relation to companies, contains a number of requirements for a company to be treated as a national of a country, including its incorporation and its registered office must be in the country in question, right?
Yes, sir.
But it also says that it must be provided that it must be substantially owned and effectively controlled by persons described in subparagraphs 1 and 2.
Yes, sir.
One is citizens, and 2 is residents or belongers. Is that right?
Yes, sir.
Well, and I take it that it must be citizens or belongers of the same country in which the company is incorporated and has its registered office. Is that right?
So it's substantially owned and effectively controlled by persons mentioned in subparagraphs.
Yes, it is. Yeah, but there's Indian definition that applies to national generally to the definition of national. The definition of nationals in Article 32.5 is applied to the agreement generally by the Article 1, isn't it?
Yes.
The definition article.
Yes, and 5A, paragraph Roman 3. So
to focus on the specific point, well, I had asked you whether the ownership and control must be in, let us call it nationals, that is to say, individuals who are nationals of the country of which the company is claimed to be a national.
yes, sir.
Is that right?
In my respectful submission, yes, sir.
Because in relation, let's see if you get if we get 32.5. Anyway, if that is so, have you established anywhere the fulfillment of that condition in relation to either of the applicants?
So in relation, the matter is dealt with at paragraph 9 of the draft originating application, where the significant shareholding of TCL is set out. First of all, Roman 2. Paragraph 9 of the draft.
Paragraph 9.
Yes, it says, at present, the issued shares in the capital of TCL are held as follows. And 20% by Sierra, well, that's Mexican, so we won't worry about that. And Roman 2, 10.20% by National Insurance Boards in the Caribbean. National Insurance Board of Trinidad and Tobago holds 9.96%. Then Roman 3, 4.19% by Unit Trust Corporation, Trinidad and Tobago. So we have 14.9% there, Trinidad and Tobago.
How do we, let's see, you see, so far as the corporate shareholders are concerned, do we have any, well, first of all, the Article 32.5A does not specifically provide for the situation where the ownership is in corporate entities. But if you, one construes it as meaning, well, the persons who own and control those corporate shareholders, do we have evidence of that in relation to any of these, and which of these shareholders?
Well, what we have here would be Roman 8. We have 31.82% by institutional investors in Trinidad and Tobago, including private pension funds. So that what you have here is a body of the most substantial block is held by institutional investors who include pension funds, who really at the end of the chain would be the beneficial owners. And that's the most significant block. Roman 8. Roman 8, yes, sir.
So it's, well, you see, it's, I mean, one doesn't want, I know, to be too literal in the interpretation of a treaty. But the definition in Article 32.5 seems to focus on the status of individual persons rather than corporations who own shares in the subject company.
I would submit that the article is to be given a purposive construction, because the modern practice of substantial shareholdings in a corporation such as this, one is going to find that the substantial blocks are not held by individuals, by other corporations or by institutional investors, as is the position in this case. And in my respectful submission, a purposive construction of Article 32.5a in conjunction with Article 222 I respectfully suggest that one is looking to find corporate bodies who are based in the country of the state, or in the state which is who is the applicant, as is CCL is in this case.
Dr. Denbo, can I suggest to you, for your comment, an entirely alternative argument? That is that Articles 211 and 222, which really are the articles pursuant to which the original jurisdiction can be invoked. In neither of those articles can one find the term national.
Yes.
And that Article 32, where the term is used, when it is used, it is specifically stated to be relevant only to that part, the right of establishment.
Yes.
And that therefore, persons who can invoke the original jurisdiction pursuant to Articles 211 and 222 are not constrained by the definition of national that is found in Article 32.
Yes. I would respectfully adopt Your Honor's indication. Your Honor, if you look at Article 32, it talks about for the purposes of this chapter, and certainly when we get to 211 and 222, it's a different chapter we're dealing with. So that Article 32 provides some guidance or indication, but the paramount provisions in my respectful submission would be 211 and 222 for the purposes of determining the status or standing of the applicants to prosecute these proceedings. One gets the flavor of the matter from 32, but the paramount provisions in my respectful submission would be 222 and 211.
I do not understand the connection with 32 at all in this, with 222. It doesn't mention the word national.
No, it doesn't, but what happens is the rule mentions Rule 10.4. One of the requirements mentions the word national.
Yes, but then it says a national means a person, natural or juridical, of a contracting party using the same word as 222.
Yes.
And of course, the CCJ agreement uses the word national instead of person.
Yes.
But then it doesn't give a definition of national.
No, sir.
The CCJ agreement.
Yes.
Which creates the problem.
Yes.
But as far as I'm concerned, I still am struggling seeing the connection with 32.5.
Well,
if the word national is not mentioned in 222 and 211, and that is only an indication. But if you look at the CCJ Act in Guyana and the one in Trinidad, it says persons in this context are those who are incorporated or registered under the Companies Act 1991.
Yes.
That's all they require.
Yes.
So I have really a problem with the connection with 32.
I appreciate it. Well, I would respectfully submit that 32 has come into the picture because of 10.4, but it ought not to be regarded as predominating or influencing the instructions we placed on 222.
Because 10.4 does not refer to 32. So it more or less states that a national is a person, natural or juridical, of a contracting party.
Yes, sir.
Which are the words of 222.
Yes,
sir. You know, it's another expression, persons of a contracting party. I think that particularly when in the corresponding article in the agreement establishing the court, as has been pointed out my brother Paulus, the word national is used. And while if you had Article 32, Article 32.5 standing alone, clearly it would not be applicable here. But of course, in the definition section, you find that national means a national within the meaning of paragraph 5A of Article 32. Anyway, the difficulty would be this. If the definition of national in 32 had no relevance whatever to Article 222.
That's right.
That's why I started off by asking you whether it meant national. But perhaps you are too readily agreed with that.
I was guided by the reference to national in Rule 10.4, but as has been pointed out by Your Honors, Justices Saunders and DeWitt, the 32 really is not incorporated or brought into focus by either 222 or 211, so that whatever it may provide in the context of that chapter ought to stay where it is and not to be carried over into construction of 211 or 222.
No doubt we would hear more about this from
yes,
Counsel for the respondent.
Yes.
Isn't 32.5 really dealing with the whole question of how you establish a right of establishment in another state, in another member state, so that it is necessary to show that you have citizenship in your originating states, and how many shareholders are in fact Caribbean people, as opposed to non-Caribbean people.
Or citizens of that particular state.
Of that particular state.
Yes.
What do you say in relation to the expression persons of a contracting, the person of a contracting body, in relation to companies, juridical person natural or juridical of a contracting party. In relation to a company, what are the criteria for being judged to be a person of a contracting body?
So I would suggest that there's certain issues. First of all, the company should be incorporated in that particular state and have its registered office in that particular state. It should carry on business in that particular state. Those to me are the three essential indicia of being a national of a particular state. So it has its legal being, it has its place of business, registered office, and it carries on business. It has management and control residing there.
But we start, so to speak, that is at the court, with a clean slate as to what those criteria are. That's the position.
Yes, sir, I will respectfully suggest that.
Right? So I don't do it. We want them to do it.
Sorry, I'm sorry, sir?
The other, well, if I may as well raise the other problem, which I thought you might help on. I know that you have addressed this in your written submissions, but it is in relation to the Guyana company and whether it has, I'm not now talking about a substantive right in terms of to complain about a breach of this breach of the obligation which is alleged to have been committed by the Guyana government. But I am on the issue of the local standby and satisfying the conditions under Article 222. Now, in your written submissions, I think you have focused largely on the rules with regard to applications of this kind, which are on a certain, appear to be at any rate on a certain premise. But I think what is more fundamental than the rules is the Article 222 itself. You know, the question I have basically is whether the Article 222 can accommodate a situation in which the benefit is being claimed by a person who is of the state, belongs to the state, not which has a right to complain of the breach of the treaty, but is of the state which has committed the alleged breach. You follow, I think?
Yes, sir.
but I wouldn't have the wording of the structure article is there.
Yes,
I don't know if you can help me with that, because it seemed to me at first blush, at any rate, that the right of the applicant must be a right or benefit which piggybacks, so to speak, on the right or benefit of the state to which he or it belongs. And it wasn't immediately obvious to me how it could be said that in relation to the requirement that it impose the CET on imports into Guyana, that represented a right rather than an obligation of the government of Guyana.
yes, sir. Well,
You take it from there.
yes, sir. In my respectful submission, it does, on the face of it, with respect to it does seem to suggest there's some legal conundrum here. That how could the government of Guyana have a right to have the CT imposed against itself, or how can the government of Guyana sue itself? The right of TGI only derives from a right of the government of Guyana. That's how I understand it, on its concern. Now, Your Honor, in my respectful submission, that the resolution of what appears to be this legal conundrum is really to look at the spirit, intent, and purpose of the treaty, which in my respectful submission is to create and vest rights in persons, both natural and juridical. And if this is recognized as one of the objectives of the treaty, that those rights do exist, then the fact that the right is not derived from the state of Guyana, or that the state of Guyana does not in any practical common sense fashion have a right to enforce, which can be sort of passed on to the individual, is of no moment. And such an approach, in my respectful submission, would be consistent with the decision of the European Court of Justice in the Van den Loos case, if my pronunciation is correct.
Van Gent and Loos.
He's the only man in there who can pronounce that.
We all understand justice.
I'm very reluctant to venture into that domain, but if I can call it a Dutch case, for sure. The approach of the European Court of Justice, Your Honor, in that case, in my respectful submission, would seem to support the argument that then one runs into an issue as to the legal conundrum as we appear to have done in this case, then the recognition or the resolution of that situation is to be founded on the recognition which that court gave the individual rights emanating from the treaty, rights which do not depend on the state being able to avail itself of those rights. And in my respectful submission, that is the appropriate approach to take in order to resolve.
In that case, was the court faced with any provision, any treaty provision akin to Article 222?
No, Your Honor, what the court was faced with was a treaty provision which akin to Article 82, in my respectful submission, which created the right in the individual. Article 82, if I can just very briefly refer to the treatment of the case and the submissions filed on the 2nd of June. Your Honors will see this matter is dealt beginning at page 11 in the submissions filed on behalf of the applicants on the 2nd of June. And the court was considering, among other things, Article 12 of the EC Treaty, which required member states to refrain from introducing customs duty or new customs duties on imports or exports, etc. In my respective submission, that is similar to Article 82, which speaks to the implementation of the CET. That tab of that case, Your Honor, this is tab 4 of the bundle of the applicants, tab number 4, the Dutch case, if I may call it that. You also see on page 1 of that, the report, on the second column, reference is made to the Article 12. The first paragraph at the top of page 1, second column, reference to Article 12 provides member states shall refrain from introducing as decree themselves any new customs duties on imports or exports or any changes having equivalent effect, and from increasing those which are already levied on the trade with each other. So this, in my respect,
assuming that Article 12, is the corresponding provision to Article 82, assume that is so, which may very well be. What the court seemed to, subject to correction, what the court in that the Dutch case was concerned with whether as a matter of substantive law, that obligation was enforceable by an individual. Yes. In our case, we're dealing here, I think, not with so much substantive rights as with a procedural requirement which limits the circumstances in which an individual or a company can institute proceedings in this court. So that while in one sense Article 222 is facilitating the bringing of such proceedings by an individual or company, it at the same time is limiting, so it seems, the circumstances in which the individual or company may do so. And in that respect, I don't know to what extent the Dutch case will take you over the line.
Well, in addition to that, sir, there's also I believe this question of, I believe you want to call it piggybacking on, that the TGI, in order to establish its locus standi, should be able to piggyback on a right which the state has against itself, and that poses the conundrum to which I referred. Now, Your Honor, this situation has been dealt with, I say with respect, in the reply file on the 25th of June, at paragraphs, starting at paragraph 13, paragraph 21 on page 10.
Before you go to that paragraph, Dr. Denver, I just want to see whether I understand the submissions properly. Is it that you're saying that the right of a national can be founded on a treaty obligation undertaken by his own state?
Yes, sir. That's my respectful submission, yes. And if then one looks at the terms of the treaty and gives it a purposive construction, as Your Honor ought, my respectful submission, to do, one can say that based on the treaty obligations assumed by Guyana, certain rights accrued to TGI. And those rights, the exercise of those rights are not dependent on the government of Guyana being able to exercise.
Not dependent on
the government of Guyana being able to pursue.
Well, again, you know, I don't want us on this side to discuss the case through counsel, but the problem is, as I said, assuming that there is a substantive right to complain, one may ask, well, to complain to whom? To which court? And it does seem to me, again, subject to further thought about it and being, getting the benefit of argument on it, does seem to me that Article 222 is a sort of threshold requirement imposed on individuals and companies with regard to its access to this court.
I was just wondering, wouldn't this give rise to the CGI particularly in a domestic court rather than under the treaty coming to us? Wouldn't that be taken up domestically?
Well, I would respectfully suggest, Your Honor, Madam Justice Bernard, if that were to be done, then the issue that will arise is that since it involves the interpretation and application of the treaty, then the judge in Guyana, if that were to happen, would most likely refer it to this court anyway.
Yes.
So you have
Well, I know ultimately it will be here, but I was thinking of the initial stage. Shouldn't he approach the domestic court first and then, if necessary, come to us for a referral?
Well, then, in my respect, the issue that may have could happen. I'm not saying it cannot, but it will end up here eventually. In my respect, this issue.
Dr. Denver, I think if TGI started the case off in Guyana, it would be safer for one particular reason, and this is that the language of Article 222C talks about the contracting party entitled to espouse the claim. Now, it's difficult to envisage Guyana espousing a claim against itself. But if you're right and can do that, you could say, right, I'll do that, and then shortly afterwards discontinue the proceedings, as it's entitled to do under Rule 15 of the Regional Jurisdiction Rules. Whereas if it's a domestic case, because the treaty is being incorporated into Guyanese domestic law, you sue for breach of statutory duty under domestic law, and then it gets referred to the CCJ to apply and interpret the provisions of the treaty, and then gets sent back to the domestic court to work out whether the other requirements of breach of statutory duty are satisfied, what the measure of damages is, and so on. So is that one way in which things can work in tandem? So whilst Trinidad, Cement Limited Trinidad, can come directly to us, because Trinidad has a claim it can espouse against Guyana or allow Cement Limited Trinidad to deal with. Whilst, of course, TCI Guyana can just go ahead in Guyana.
That's a course of action which I could not deny may happen. It could happen. I couldn't deny that. But as Your Honor said, it would come here. Essentially have to come.
So the problem is, looking at these two interrelated actions, perhaps we need to let the Guyanese action go ahead first of all, because if TCI Guyana actually gets full compensation, then there's no loss in value of the shareholding of the holding company in Trinidad, so the Trinidadian company wouldn't lose anything.
Well, I would, with respect, suggest not, because the process of progress, one has no control over that, and it is quite possible that it could get lost in the system, and the vindication of the treaty and upholding the community law, all those issues would tend to get lost. That's
so that's one reason why we should actually take on the Guyanese company's claims, because otherwise the time scale would expand dramatically before these issues were resolved.
Yeah, I would venture to suggest that, yes, sir.
Well, are we entitled to assume that?
Well, I wouldn't say you're entitled to assume that. That may be a reality of which Your Honor may take judicial steps.
Maybe, but you see,
well, Your Honor, there's one further point which, in relation to the standing of TGI, and that's I would venture to suggest with respect that the question of the piggybacking of TGI on the government of Guyana is an issue which is predicated on a doctrine that only states can be entitled to enforce rights in international law. And that seems to be the foundation of the suggestion that the Guyana government be able to establish.
I don't think that is not what is operating in my mind anyway. What is operating in my mind is that article is the effect of Article 222, as I have explained. The liberal effect as well as the restrictive effect. But I think that, whether or not states are the only objects of international law, one is faced with Article 222, which is quite specifically addressing the circumstances in which and the conditions on which individuals and companies may bring proceedings.
Yes, sir.
Well, Dr. Edmo, we have already, with our help, particularly mine, have already exceeded 1 hour, but I think that you're entitled to some latitude since we have been kicking you perhaps off your intended course.
Well, not totally, Your Honor, because I think those were the issues which Your Honor had telegraphed on the last occasion of the CMC in May, that was the main issue in relation to TGI standing, which Your Honors needed to be addressed at that, so that that was the time which was usefully spent.
Yes, well, I don't know. We would give you, as I say, some more time if you wish to address us on any other aspect of the matter.
Yes, sir.
The matter to you to decide.
Yes, sir. Your Honor, in my respect for submission, I know Your Honor would have read the submission, so I don't intend to take Your Honor for any submission. I know you have read them. So if I can just complete my overview, yes, for the purposes of putting an end to my address. And Your Honor had said to me that what was the relevance of the Congress of Guyana, and I had said that it went to discretion. And Your Honor, I think it's important to note that what is at issue here as a broad matter of public interest, public importance, would be the preservation of the integrity of the treaty. One has had a TCL acting in a fashion which is wholly consistent with the objectives of the treaty. TCL is engaged in a substantial cross-border investment of over $10 million to put down this state-of-the-art facility in Guyana. And that would have been done on the faith of and with the legitimate expectation that it would enjoy market access. It would have the opportunity to expand and produce and sell all it could produce and supply to the Guyana market. This has not been possible because of the steadfast refusal of the government of Guyana to implement the CET. Now, the honors will have noted that this suspension was done in September 2006 for 1 year. And we approached December 2007. 1 year had passed. And the COTED at its meeting in November 2007 did quite clearly suggest to Guyana that it should once again implement the CET, because the supply issues which had been raised in the past were no longer in play. But what do we get? We get total silence. Nothing has happened. The CET still remains suspended, although on what legal authority one does not know. And what you have here is a flagrant breach of community law. And this, in these circumstances, is my respectful submission. This honorable court, as a guardian of the treaty, ought to intervene to uphold community law. And that is why I'm asking Your Honors to exercise your discretion to grant special leave to these applicants to prosecute these proceedings. TCL has engaged in a substantial investment which is being jeopardized by this continuing situation. And Your Honors have the correspondence which is annexed to the originating application, draft originating application, correspondence between the ministers in Guyana, that's the Minister of Trade, and representatives of TCL in the period of December, going back to October, December 2007, asking for the reintroduction of the CET. All of that correspondence has been ignored. And to top it off, one has, if I can draw to your Honor's attention, a document of the Guyana government which clearly recognizes and admits that it has not dealt with the CET in a fashion consistent with its treaty obligations. And this document, Your Honor, is to be found at Exhibit I. Exhibit I to the respondents' submissions. Exhibit I is a document headed Bureau of Statistics, a Guyana government document. You also see its calendar of key economic benefits, December 2007, Bureau of Statistics of Guyana, page 4. And on page 4 of that document, in the left-hand column, the second paragraph,
Are you sure this is I?
Yes, sir. The respondents bundle. Respondent submission, yes. It's page 4 of that statement. Left-hand column, second paragraph. Yes. If I may read very briefly. And this is the government of Guyana's document. The Guyana government will continue to waive the 15% CET on extra-regional cement, even though Cabinet Secretary Dr. Roger Luncheon acknowledged that the government did not follow standard procedures by applying to the CARICOM Secretariat for approval. CET is not being applied now, explaining that the government continues to waive the CET on extra-regional cement. The Cabinet Secretary did not reveal the duration of the current waiver when asked about the time frame. In October, the CET waiver on cement came to an end, and following a meeting with cement importers, Tourism Ministry and Commerce Ministry said that the Ministry would continue the waiver on cement despite opposition from TCL. TCL maintained it can supply the entire Guyana market from its new bagging facility. So, Your Honors, here we have, in my respectful submission, clear admission that the CET has been waived for over a year and the waiver has been renewed. On what legal authority, no one knows. There's been no document indicating that. And more importantly, it's quite clear that the supply issues have all been cleared up. Now, in the face of that, no amount of euphemistic description of the government of Guyana's conduct as not following standard procedures will do. That does not avail the government, because it is quite clear in my respectful submission that we've had a breach of its community obligations, and this is a continuing situation where there's been no indication of an intention to depart from that state of affairs. It's a situation, in my respectful submission, which cries out for Your Honors to intervene in order to protect the integration process and uphold the law governing relations between states in trade and investment matters under the CARICOM agreement. So I'd ask Your Honors, to grant leave, special leave to the applicants in this matter. I don't think there's anything more which Your Honors would ask me to deal with. Those will be my submissions.
Thank you, Dr. Tendo. We are going to take a 15-minute break now, and when we return, we will hear the Attorney General of Guyana in reply. So we will return at what, 20 to 12? Yes, Mr. Attorney, would you like to address us now?
May it please you, Your Honors. Rule 10(4) of the rules provide as follows. Proceedings by a national. 1. A national wishing to commence proceedings, etc., and continues. National is defined in the treaty. In Article 1, use of the terms appears. And a national is defined as means a national within the meaning of paragraph 5A of Article 32. It is my submission, Your Honors, that the meaning which has been ascribed to national in Article 32, 5A applies to every use of that term in every sphere in the treaty. My submission, Your Honors.
In the revised treaty, Mr.
Yes.
Attorney? And when you say in every sphere, what do you mean?
Every time the phrase is used, Your Honors, it carries the definition which has been ascribed to it
Is it
in the
used
treaty.
in Article 222?
Sorry, sir?
Is it used in Article 222?
It is used in natural. It is used in the sense that the words persons, natural, or juridical.
You're saying it is comprised in the phrase persons natural.
Natural, sir. That when in that context the expression is used, that the definition which has been ascribed to it in Article 1 is what ought to be construed.
Have you looked at the definition of national in the rules, the originating rules?
Yes.
There it says means a person, natural or juridical, of a contracting party within the meaning of Article 222 of the treaty.
Yes. So,
but Article 222 does not define national.
Does not define.
It speaks of persons.
yes, does not define it. What it says, national, in the rules, madam, means a person natural. So what they are doing there is that they are using that phrase national interchangeably with natural. Natural or juridical. And they are thereby attempting to define what is meant in Article 222.
But I think the point that is being drawn to your attention is that while the term national appears in the rules and in the agreement establishing the court, it does not appear in Article 222.
I appreciate that, sir.
And certainly, so far as the definition of the term national in the rules is concerned, that is linked to Article 222.
Yes.
not Article 32. And in the agreement establishing the court, the term is not defined.
It is not defined. But I am submitting, Your Honor, that when you look at the context in which it is used, the definition which has been ascribed to it in 32.5 is the definition that ought to be applicable. And that definition is transposed in Article 222.
Yes.
Your Honor, it is my submission that my learned friend has not satisfied that definition, in that in the course of his presentation, he spoke of management and control. And nowhere in his pleadings has he established management and control. What he adverted to is what appears at paragraph 8 as a brief history and 9, and wherein it is stated that the largest shareholding was 20% by Sierra Trading Cemex. Your Honors, we have laid out in our submissions the inadequacy of my learned friend to satisfy this condition. Your Honors, in construing Article 222, cognizance must be taken of Articles 193, 198, 204, and 223. It is significant that when a contracting party alleges a violation against another contracting party, that contracting party is obliged to enter into consultations in accordance with Article 193, attempt to arrive at settlement, amicable settlement, within the provisions of Article 198. Further, to take steps to arbitrate a dispute. And it is the contracting party is mandated, Your Honors, under Article 223 to legislate to ensure observance of arbitration.
Yes, Honorable AG, where is the authority?
Where is her?
Your authority to say so.
I'm sorry, sir, I didn't.
Where is your authority for saying that the applicants needed to have sort of gone through these?
I'm not saying the applicants, sir. What I'm saying is a contracting party.
Yes.
If it has been instituted as under the provisions of Article 223, each member state shall provide appropriate procedures in its legislation to ensure observance of agreements to arbitrate. What I'm saying, sir, is that assuming the contracting party institute proceedings, then these various procedures have to be complied with.
You are in fact saying that this thing here is premature.
No, sir. What I'm saying, sir, in the court exercising its discretion, the court has to take account of the fact that there is no procedure when an individual or a private seeks leave to institute proceedings.
Well, Honorable AG, I am in fact supporting you for 211 of the revised treaty
Yes.
says, subject to this treaty,
Yes, sir.
the court shall have
Yes, sir.
compulsory jurisdiction.
Yes.
So something must trigger the compulsory jurisdiction of the court. And you are right, but I don't think for the reasons which is
The reason. Yes. Very well, Your Honor. Your Honor, so that in construing, sir, these matters have to be taken account of. And I don't wish I have set out in detail, sir, the arguments that we advanced with respect to the interests of justice. The learned friend has sought to distinguish the authorities which we cited dealing with special leave, but I submit that those are the only authorities that are available dealing with special leave. And the fact that they deal with special leave to appeal is only used by us as a guide to how special leave applications ought to be considered.
Yeah, but Honorable AG,
Yes, sir.
special leave in the context of Article 222 is qualitatively different from special leave to appeal as found in Article 25(4) of the agreement establishing the CCJ. They are qualitatively different.
They are qualitatively different, sir, but it can be used as a guide in adverting attention to what is the requirement for special leave. So that the fact that it doesn't deal directly with that kind of situation doesn't mean it has not to be considered. Because it is, Your Honors, why I was pointing to the procedures for consultation and arbitration is that to demonstrate the difference when an individual seeks to institute proceedings as distinct from when the state seeks to institute proceedings. Your Honor, because the rationale for that is that it is very unlikely that the state will seek to institute proceedings against another state in a situation where the treaty itself can be called into question. That is why you have this elaborate mechanism for arbitration, consultations, and all this sort of thing. So in the court exercising its discretion, it can take these factors into account.
Yeah, but Honorable AG, for all those disputes modes which you have just referred to, these addresses where states are involved.
Yes.
Not when an individual or private entity is involved.
Yes, sir.
They all speak to states which have, sort of differences.
Yes, sir.
But this is a qualitatively different situation.
It is
addresses individuals or private entities. And the other modes of disputes, sort of settlement, consultation, and so forth, those refer to situations where states only are involved.
Yes. Your Honor, what I am submitting is that because of those differences, because of to ensure that litigation is only at the last resort, that the court in the exercise of its discretion ought to be very hesitant to grant special leave. That is the way in which I am putting the argument, sir. And I ask the court to take account. My learned friend has adverted to the fact that the question of that the Guyana government, sir, has acted in a sort of dictatorial manner. I ask the court to take account of these facts, sir. Guyana was given a waiver with respect to 10,800 metric tons on June the 14th, 2001. At the 11th meeting of COTED on the 22nd of 2001, derogation was granted to Barbados, Jamaica, and Trinidad. That decision was further extended on the 18th meeting of COTED on the 4th of January 2005. At the said 18th meeting in 2005, it was mandated that a comprehensive examination of the production and trade in cement in the region and an examination of the operations of TCL be conducted. As a result, CARICOM Secretariat, with financial support from the Commonwealth Secretariat, commenced an examination and an independent audit of the supply by TCL of cement in the region. The results of that audit were supposed to have been submitted to the 26th meeting at COTED in May. Yes. At the 17th special meeting on 9th September 2006 of external trade negotiations, OES states were granted waiver, Suriname and Trinidad and Tobago, for 2 years. Your Honors, since March 2004, the Guyana government took a decision to have cement imported into Guyana outside of the region. And that decision was a decision which the Guyana government took every year. TCL never complained, Your Honors.
Mr. Attorney, not to interrupt you, but don't you think that's going into the merits of...
No, Madam, I am attempting to show that this attempt by TCL is at a very late stage. That Guyana government continuously since 2004, Madam, has been having waived unilateral the 15%. TCL never objected. In fact, and that the other issue, they had to show as well that the state, the contracting state, which was entitled to take proceedings, omitted or declined to espouse the claim.
But did Guyana ever apply to COTED for permission to suspend CET after 2001?
No, Your Honor. The only application was made in 2001.
Yeah, but ought they not done so?
Your Honor, they ought to have done that, but it was not done. But it would appear that because of the difficulty that was being experienced, the government of Guyana took a decision to implement that policy on a yearly basis. And it was because TCL, Your Honors, appreciated the inadequacy of their ability to supply, not only in Guyana, throughout the region. And that is why the Trinidad government themselves never took any proceedings to institute proceedings. Because the Trinidad government itself had taken a decision that TCL could not supply adequately the region, nor Trinidad itself. And that is why, Your Honors, we had attached a statement which was issued by the Minister of Trinidad and Tobago and which was published in the Guardian newspaper of Sunday, the 16th of July, 2006.
Mr. Attorney, wouldn't all of that go towards mitigation of any penalty or punishment?
It is.
I mean, what you have to deal with is whether there was a breach of the provisions of the revised treaty. And if there was a breach, whether in fact there was any right or benefit which inured to the applicant. I think that really would have been where I would concentrate on. I would hardly, in fact, I don't consider with respect that the fact that there have been consistent breaches of the revised treaty by the Guyana government as enhancing your position. I don't
know it
enhances your
I'm not seeking to say it enhances or.
But you must be saying that because I've asked you why you are doing this, and you say, well, it's an important point.
It is an attempt to show, Your Honors, that TCL recognized that despite the fact that there was this breach, it didn't disadvantage them, Your Honor.
Well, is that a finding of fact we have to make?
Well, Your Honors, assuming TCL themselves took that position, then Your Honors can use that as a basis for determining whether special leave should be granted.
Mr. Singh.
Yes.
A difficulty I have is that you are here telling us about the motives and reasons for action or inaction on the part of TCL and on the part of the state of Trinidad and Tobago. They are both here. The state of Trinidad and Tobago chose not to say anything, and I think perhaps it would be better if we heard from TCL itself about their own motives, as distinct from you purporting to better than they can tell us what those motives were.
Your Honor, I'm not using it as a basis. I'm using it to show that TCL themselves accepted that they could not supply the requirements of the region. And whether it was a decision which was given by quoted or not, they accepted the decision.
Yeah, but Honorable AG,
yes, sir.
With the greatest respect, sir. Guyana ratified the Vienna Conventional Law Treaty on the 15th of September 2005. Article 26 of that convention addresses the rule of pacta sunt servanda. Treaties must be fulfilled in the utmost good faith. That is the point from which I think with respect, Honorable AG, we all should start.
Your Honor, I appreciate that. And I accept that the Guyana government ought to have approached COTED to ensure and to get the permission to have the waiver implemented. Your Honors, I accept that. But what I am saying is I am attempting to demonstrate that when the court has to consider the interest of justice as the overriding criteria for the exercise of its discretion, that those factors can be taken into account to determine whether the overall requirements of justice would be able to be utilized in such a way that leave ought not to be granted. That is how I am attempting to argue it, sir.
But I understand the TCL to be saying that whatever was been in the position before, once the Guyana company had been established and began operating, there was no question of any inability of the two companies to meet the demand for cement in Guyana.
No, sir.
So that all I'm saying is that if the criticism is that they did not complain sooner, that may provide an explanation. That is that once they were in a position to supply the whole market, that is when they began actively to try and persuade the Guyana government to lift the suspension.
Your Honor, that is an issue which is, there's a difference of opinion.
But it's certainly not one I agree with you. You know, we are not and will not be in a position to make a finding at this stage, at any rate, on that issue.
Yes.
But I think that you've heard enough from the court to suggest to you that maybe this is a good time to move to another point.
Yes. Your Honors, as I had indicated, we have put forward our arguments in the written submissions. And with respect to the losses which TCL submitted that they have suffered, and that is why they are seeking leave to institute proceedings. I wish to draw attention to WISE Stock Watch News, which is a release that was issued on the 2nd of May 2008, which deals with TCL Cement Limited. Put it on. And Your Honors, this particular paragraph.
What page is it?
Page 5, Your Honors. Yes. No, Your Honor, this is a Stock Watch News. Put it on.
Do we have copies of it?
No, Your Honor. I'm putting it up on the screen now, sir. Put it on.
Is this part of your affidavit evidence?
This is not part of the affidavit evidence.
Well, how can we look at this? And what entitles us to look at this?
Sorry, sir?
What entitles the court to look at this Stock Watch News that you're putting up?
Your Honor, there is a provision whereby the court can, on its own volition, look at reports, look at details, and call experts of their own. I am submitting that this is a release which would be the court ought to look at, which is a report which was put out by the applicants and which relates to the applicants' ability. There's an allegation that as a result of what the Guyana government did, they suffered losses. And this is why they are claiming compensation and damages. I'm asking the court to look at this report to be able to determine.
Who is the author of the report?
It's a Wise Stock Watch News, sir. It's reported in the.
But also, Mr. Attorney General, it says there was an increase of 28.3% on earnings per share.
Yes, sir.
If things have gone well for them in Guyana, it could be a 50% increase or 7% increase.
But the fact is, Your Honor, that they are making substantial profits. So, Your Honor, that is why, Your Honor, I am drawing attention to the fact that the Guyana government, since 2004, sir, has been allowing non-regional cement to become. And PCL never complained. And that is why now that the complaint is raised in February 2008 for the first time, when they're showing that their profits are up, the directors have approved performance to increase revenue and operational deficiencies. So these are all matters that the court ought to take into account. And because, you see, Your Honors, there is no mechanism for an amicable settlement when an individual seeks leave to institute proceedings. Which, on the other hand, had it been the TCL, assuming for the sake of argument, sir, that it was TCL that has instituted these proceedings, TCL would have been obliged to take steps at conciliation or an amicable settlement.
You mean the state of Trinidad, assuming that it was the state of Trinidad?
Yeah, yes, sir, I'm sorry. Assuming TNT had taken steps, Your Honor, here Guyana has violated the treaty, and they would have been obliged to take consultation, arbitration, to have a resolution, which is not available, so that the court can take that into account in determining whether in the interest of justice, special leave ought to be granted. In addition, the court can take into account the treaty that is afforded to protect consumer rights as well. The treaty provides for that. And so that, as well as to ensure that a dominant position of a monopoly or something should not be abused. Those are all considerations, Your Honors, that I'm asking the court to take into account in determining in the interest of justice. That is why, Your Honor, that is why that phrase is used in 222. Because assuming we agree there is a violation, you violated the treaty. But that's not an end to the matter. You have to consider whether in the interest of justice, the claim should be allowed to be exposed. And those are the considerations which the court have to take into account in determining whether the interest of justice can warrant such a situation.
Mr. Attorney, are you satisfied that they have satisfied the court on the conditions that pertain in 222, that they are in persons that they're entitled to espouse? Because
that what, ma'am?
For the benefit, that the treaty was for the benefit.
Well, Your Honor, we have raised that argument in our written submissions with respect to being entitled, and it's only on the basis if there's been a failure to espouse a claim or omitted to espouse a claim. And we have raised the argument as well as whether it is to the benefit, inured the benefit directly. We raised those arguments in our written submissions. And I'm not going to attempt to repeat anything that appears in the written submissions, Your Honor. I'm merely seeking, Your Honors, to address matters which was not addressed in the written submissions, in a way to attempt to demonstrate to Your Honors why it would not be in the interest of justice that leave should be granted. Those are the arguments I wish to advance, unless there is anything that the court.
Right. Did you, Mr. Attorney, make any submissions on what is called a Dutch case?
I don't recall whether we did in a written.
In the written submission?
Yes.
You did.
You did.
I think you did make reference to it.
We probably just made. I don't recall, Your Honor, but I believe that we did.
What did you say? Well, if you can just remind us what you said.
Yes.
I think that this is paragraph
91, ma'am?
Paragraph 91.
91. Yes, sir.
Page 15.
Yes.
Is it your view that Article 82 of the treaty does not confer any right to anyone?
Article
82.
82.
Does that confer a right to a state?
To a Guyanese national, sir.
To Guyanese? No, I'm asking in general. Does that confer, in your view, any right to a member state? Article 82.
82. Yes, sir. Your Honor, Your Honor, it seems that it is only applicable because it says the member states shall establish and maintain a common external tariff in respect of all goods which do not qualify for community treatment in accordance with plans and schedules set out in the relevant determinations of COTED. So their obligation there is to ensure that the member states as such comply with that article.
Yeah.
So it doesn't speak specifically to any individual.
But does it confer a right to a member state, another member state?
It confers a right on another member state, sir.
And on its nationals?
Pardon me, sir?
And on its nationals.
And on its nationals,
But
as a result of, yes.
Yes, but it does not confer a right
directly
to the national of the state who would breach this provision.
There is no such thing.
So, because I'm trying to figure out
yes, sir,
how to see this. Now, Article 222A says that rights and benefits conferred by the treaty or under the treaty to member states can inure directly a benefit to individuals. But I went through the treaty. It only contains obligations for states. It doesn't confer with so many words rights to member states.
Yes.
But of course we have to, the opposite of a duty is a right. So in an indirect way it confers rights, correct?
Indirectly, sir.
Yes. But that is the only right it confers. So if it now only confers rights to nationals of other member states and not to your nationals, would that not be a discrimination on the basis of nationality only, which is prohibited by the treaty itself in Article 7?
But that would be a totally different issue, Your Honor.
Yes, but anyway, in connection, in the context, it might create a discrimination on the ground of nationality. Does it not?
Might, sir. It doesn't, on the face of it, discriminates, but it might be considered discriminatory.
Well, if let's say a company from Trinidad or Grenada or any other country could file a case against Guyana, but only a company from Guyana cannot do that. That sounds like discrimination on the ground of nationality only, but I don't know what your view is.
Yes. Your Honor, that I agree with you, but it would be dependent on so many other factors. Your Honor, unless there is some other inquiry.
One other question, Honorable.
Yes, sir.
If under Article 82 there is an obligation on the part of Guyana to impose the CET, does not this create a right in any other member state to enforce that obligation?
They have an entitlement, sir. I wouldn't wish to put it as a right. If they wish, we are honest, but the court has to take account that we are dealing with member states, sir. And it is there might be an entitlement, but the member state might have good reasons not to institute proceedings. Because you're dealing with a community relationship. And it is not a simple matter because there has been a violation, the state would seek to enforce it. You're dealing with political and other considerations. And as a result of that, it might not be advisable to institute proceedings.
Well, that's right. That's why individuals or companies are given the right to intervene. And I think the question really with regard to Article 82 in CARICOM, where we've got 12 countries,
yes,
is this creates an obligation on Guyana to the 11 other states to maintain the common external tariff, and probably an obligation to the nationals or juridical or natural persons of those states.
Yes.
And then the key issue is whether there's also an obligation to nationals of its own state, of Guyana. So you're not seen to discriminate against nationals of your own state in contravention of Article 7.
But the way I see it, sir, because first there must arise that the violation is enforceable by the state itself. The state itself has to be entitled to seek to enforce the violation. And if the state, how would the state seek to enforce a violation against itself?
Well, that's
and therefore,
an obligation owed to itself. It could be an obligation owed to citizens of its own, to its own citizens.
And that is why my friend was speaking about legal conundrum. Why would a state, how could a state seek to enforce a violation against itself? It cannot occur.
Yeah.
Would you say, Attorney, that in such a situation, the nationals of the country would have a claim in the
domestic law?
Domestic court?
Domestic court, Your Honor.
For that. But then, of course, ultimately it will turn on an interpretation of the treaty.
But ultimately it has to be determined by the domestic court.
Yes, but if the domestic court is called upon to interpret the treaty,
yes,
that can only be done by this court.
Yes.
So it means that, in effect, whoever hears it, the judge in the domestic court in Ghana will have to refer it to us for interpretation.
Yes, but only for the purposes of the interpretation. The consequences is a different matter, and the consequences has to be decided in the domestic tribunal. Because it is impractical for the state to seek to enforce a right against itself, a violation of a right against itself.
With regard to the question of discrimination,
yes,
but if the nationals, let's use the word nationals for shorthand, if the nationals of each CARICOM state has the same facility for suing, for bringing proceedings for breaches by other states of the agreement, but is under the same disability with regard to its own state, would that amount to discrimination?
Your Honor, that is why I was saying it would depend on the special facts and circumstances whether it could be considered discriminatory or not.
Yes, all right. Is there anything else that you would like to ask?
Article 9. Attorney, that says that there's a general undertaking on implementation. Is that a provision which creates a right in community and nationals? So that if a state chose to breach the revised treaty, the community nationals have a right of action or a right to have that provision observed.
Your Honor, I'm reading it for the Article 9, Your Honor.
Yeah, member states shall take all appropriate measures, etc. to ensure the carrying out of obligations rising out of the treaty. Yeah.
That is an obligation of the states, Your Honor.
Yes. Does that engender a correlative right
On an individual?
on an individual, on the part of states and in community nationals to have the treaty observed?
I am not sure as to how this could be enforced, sir. Because if there gives them a right, then there has to be a mechanism to enforce.
Well,
I'm not
here
sure.
on the question of enforcement and the question of whether the right exists.
I think it is.
If you look at the last sentence of Article 9, that says they, in other words,
Yeah.
member states,
Yes.
shall abstain from any measures which could jeopardize the attainment of the objectives of this treaty.
Yes.
If a state say we're not going to abolish the common external tariff, they are taking measures which could jeopardize the attainment of the objectives of the treaty, and that would enable someone to come to the CCJ to rectify that situation. Is that right?
Yeah. Assuming a state was to take that as a position, then I submit, then the state could be brought before the CCJ. But it must demonstrate an intention to violate the treaty and consistently. Yes. Your Honor, let us be realistic and look at the situation. TCL allowed this violation to continue for years. Why? What is the rationale for it? The rationale is simple. They could not comply. They could not supply.
It seems to me that is not the point at all. The point is whether, in fact, the state of Guyana has flouted its treaty obligations.
Your Honor.
Of course, there's another issue as to whether TCL has the necessary local standard. But to try to excuse an apparent disregard of the treaty provisions on the basis of TCL's actions or inaction, I don't quite...
Millard, I'm not seeking to justify it, sir. I'm only attempting to seek to rationalize why it was that TCL did not take steps earlier.
So I'm
not seeking to justify it.
They're now taking steps.
Well, what I'm saying, sir, you come too late in the day. This is, I can't raise laches against you. I can't use undue delay against you. But
they're saying in 2007 they did make significant loss of profits.
Sorry, sir?
In the year 2007, TCL was saying that they lost over $500,000 of profits.
Yes.
So maybe they didn't bother in 2004, 2005, 2006. There was too little money. But after establishing a new company in Guyana, they did that in the hope and expectation they would be able to produce lots of cement and make large profits. And they alleged they've not been able to because the foreign cement was brought in, undercutting their price.
I wouldn't entertain any discussion because I am not accepting that they lost profits, sir.
Well, that can explain why they're bringing action now, because they have. You may dispute that, but that's something for the substantive case. We can't make any finding on that today.
Your Honor, but I ask you to take account of those factors when you're considering whether in the interest of justice it ought to be allowed to do that.
Mr. Attorney, that is under the heading of undue delay in coming with an application for relief. Is that it?
Sorry, sir?
Is it under the heading that all of this points to undue delay?
Yes, sir.
Coming late in the day to seek relief? In our discretion, we will say, look, you've taken too long to come here.
This is the way. I haven't used the expression undue delay, but I've said...
I don't like that expression either. It took too long to come here.
And that you might have had good reasons why you never wanted to do it. I'm not saying that you said it. Your Honor,
they are complaining about the suspension of the CET in 2007, is that right?
Sorry, sir?
They are only complaining
Yes, sir.
about the suspension of the CET in 2007.
7. Yes, sir.
Well, is it too late for them to do that?
Mm. Well, the way I was putting the argument, sir, is the suspension took place since 2004 continuously.
I would like to ask one question.
Yes.
Coming back on your first point, the national,
Yes, sir.
in the context of Article 222.
Yes.
Now, you seem to link that to Article 32(5)
Yes.
of the treaty.
Yes, sir.
So that's why I'm wondering, if we go back to the Guyanese CCJ Act, where they incorporated the treaty, Article 5, B, where it says persons, and A, who are citizens, permanent residents or residents of Guyana, and B, persons who are incorporated or registered under the Companies Act 1991 may, with the special leave of the court, be allowed to appear as parties in proceedings before the court, and then you get the same conditions as in 222.
Yes, sir.
So the act which incorporated this in Guyana says persons, juridical persons who are incorporated or registered under the Companies Act 1991.
Yeah.
That's all it says.
Yes.
There's no reference to Article 32. Now, that is quite striking because actually all the countries, all the member states enacted this provision in this way, except Jamaica and Dominica, who do revert to Article 32. So there are two countries who seem to have a different approach. But what is important for this case is that Guyana, that only requires persons, a juridical person, who is incorporated or registered under the Companies Act 1991, which I think this Guyanese company is. So that's why I'm a little puzzled about this insistence on 32(5) of the treaty, because the very act that incorporated the treaty doesn't do that. Neither does the one in Trinidad.
Except, sir, that the treaty is applicable to all the member states.
Yes.
And they have incorporated the treaty. And by incorporation of the treaty, that has to be construed that the treaty is the overriding legislation.
But my question is, why did Guyana then incorporate it in this way and not referring to Article 32, which, for example, Jamaica and Dominica did?
Yeah. Your Honor, I cannot give an explanation.
Oh, okay. Thank you.
Thank you, sir.
Yes, thank you, Mr. Attorney.
Very well, sir.
I don't think, Dr. Denbo, I don't think there is anything new that would call for a reply.
Chairman, except for Your Honor, the reference to TCL not accepting that it couldn't supply. We have no.
Would you come to the podium and make it brief, would you?
Much obliged. Your Honor, if I can just deal very briefly with 2 points on the supply issue, very briefly. First of all, it was said by my learned friend that Guyana had a waiver of the CET in 2001. If I can point out to you, there's no evidence of this at all on the record. No evidence of that. Secondly, it was said that TCL had accepted it couldn't supply the region. There's no evidence of that at all, to be honest. There were supply issues, but the complaint relates to post-December 2006 when the TGI plant became operational. And there has been no dispute from the government of Guyana about a supply issue after December 2006. That's where the claim is focused. So those are the factual corrections which I would like to make. That's all, Your Honor.
Yes, well, thank you. We reserve our judgment and we'll have it down in due course. All right.